Good afternoon and welcome. This is a special meeting of the San Francisco Sunshine Ordinance Task Force, called for Tuesday, April 20th, 2010 at 5 p.m. and beginning at 5:09 p.m. May we have the roll call, please?
Member Craven Green?
Here.
Craven Green present. Member Nee?
Here.
Nee present. Member Colton? Colton present. Member Manny? Member Manny excused. Member Washburn?
Here.
Washburn present. Member Caneba? Caneba excused. Member Johnson? Johnson excused. Member Wolf? Member Wolf absent. Member Chan?
Present.
Chan present. Member Goldman?
Present.
Goldman present. Member Williams? Member Williams excused. Mr. Chair, there is a quorum.
Okay. Member Wolf is probably en route at this point. He emailed me and said he expected to be here about 5:15. He should be marked excused until then because he's coming from work.
Thank you, Mr. Chair.
Also, it should be noted that there are 4 provisions that Mr. Wolf would like to revisit particularly under, these are provisions under Article 2, which deals with the open meetings. At that time, we will go back and revisit those items with Mr. Wolf so that we can get any revisions done that we see are appropriate. But for now, we are moving ahead with Article 3, starting with what would be the new section 67.33, I believe. That would be the definitions. We did go over the definitions at our last special meeting, which was held 4 weeks ago, I guess. And at that time, I think we agreed that the definitions we had established were fine. They were appropriate with all of us. So with that, I believe we're ready to I'm sorry, not 6733. My mistake. I believe it was 67.19. Definition 67.19. So I believe we did agree at our last special meeting that these definitions are appropriate for us. So we're ready to proceed now with section 67.20. What I am going to do is to take comment first from members of the task force. And once the task force is through discussing, if we have any motions, I will call for public comment. If we don't have any motions, I will also call for public comment. But I want to be sure that members of the public are allowed to speak on any motions that come forth. So it's not that we don't want to hear from you right up front. It's that we want to give you the opportunity to hear what we do and then comment on as you see appropriate. So with that, let us proceed now with section 67.20. Is there anybody on the task force who wishes to comment? Member Cawthon. Microphone, please.
I have a couple of questions. Let's see. On page 57 at the top, this is under C, number 1. Where it says that a reasonable copying fee will be charged not to exceed the actual cost of the item, or 10 cents a page, whichever is less. We had in the prior ordinance a statement that multiple copies would be 1 cent a page. Did we put that somewhere else? I mean, in other words, if you make a lot of agenda items for, say, the Library Commission, then if they reproduce that for you, they would only charge 1 cent a page.
Yes, that's in the agenda.
That's elsewhere?
That's in the prior section.
It's in B.
Okay. And the other question I have, I see here that you've put some make nice stuff in for the departments, which I think is a good idea. I think 4 is a good deadline for submitting immediate disclosure requests. When you talk about on number 2, line 3, that the requester can review the records without unreasonable delay and without requiring an appointment. This next line I question, the new one, or at another time convenient to both the requester and the custodian of records. Am I assuming that you put that in to provide some leeway to the department? And does that mean if it's not convenient for the custodian of records that they can't come without unreasonable delay or without an appointment?
I think we want to make this as easy for all parties as possible. I mean, it's, the custodians of records may have other duties as well, and particularly if at a given moment they are understaffed or just overwhelmed, certainly, a custodian of records might inquire of a requester if the requester could maybe adjust his or her time requirements a little bit. This is not to excuse a custodian of records from acting in a manner convenient to the requester, but maybe it's basically to ensure to allow some flexibility. And if a custodian honestly is having some sort of constraint and is not trying to violate the ordinance or violate a request willfully, those, I think, some considerations need to be made there.
I agree, but what I worry about is that a department will say, well, this is not convenient for me, so you can't see it today. And when you come in if you come in and ask to see something, they'll say, this is not convenient for me, you can't see it now. There may be some reason for that, but I wouldn't like to give them an opportunity to delay producing the records because they said it was inconvenient.
But it has to be convenient to both. It can't just be convenient to one. So if it's not convenient to both,
I don't see why it doesn't read that way. Oh, to both.
or at another time convenient to both the requester and the custodian of records. It's clear. So we tried to make it clear that, one side can't say, well, that's, not convenient. The department can't say it's not convenient.
Okay.
As for me, I'm satisfied with this section the way it's amended.
Okay, I had just a couple of, I had a few things here. First of all, in paragraph A, on the fourth line, where it says forms to streamline request, I believe that should be requests, plural. And then on the same line at the very end, members of the public who request. There should be no S there. That's a grammatical. Now, under section C2, at our last meeting, Mr. Warfield raised a rather strong objection, and I tend to agree with it. At the very bottom, the final sentence, in no event shall the custodian of records be required to set the records aside for review for longer than 14 days unless agreed to between the requester and the custodian of records. We should either expand that maximum or else knock it out. The records are there for the convenience of the public, and to me, having that maximum there, it's not quite right. I think that should be reworked somehow.
Well, I think Mr. Warfield's main point was that there wasn't a minimum, so why should there be a maximum? So I think that was his main point, is that there needed to be a minimum amount of time that they should be set aside for. If you recall, Rick, we had a number of departments commenting on this provision, wanting to know how long they needed to keep these records available. They're public records, but they're also records that, in some cases, are being utilized and needed for the day-to-day operation of the departments. So there is a significant, there can be, not always, sometimes these are historical records that no one really cares about, and they can be left aside for months without causing anyone any harm. But what we were hearing from some folks was that especially with records that are operational records that they need, it is a problem to have them set aside for an indefinite period of time. So that's why we put this in here.
Okay, should we perhaps add a sentence then, or a phrase establishing a minimum?
That would be fine by me. I mean, we can say, in no event shall the custodian records, I mean, if we wanted to say it's 2 weeks, right? You have to set them aside for a minimum of 2 weeks, but you're not required to set them aside for longer than 2 weeks. That would satisfy me. That would think 2 weeks is fairly reasonable. Under the ordinance, if the requester is going out of town during the 2-week period as to which the department produces the documents, then the department can't just say, oh, well, tough luck. They have to schedule another time for the viewing. So, I mean, I don't think that's necessarily the concern, but if we could say, in no event shall the custodian of records, or I should say, the custodian of records shall be required to set aside the records for review for at least 14 days unless agreed to between the requester and the custodian of record, but in no event shall be required to set the records aside for more than 14 days.
Okay.
Rick, I would suggest, because we're making a substantive change to this section, that we take public comment on this section, and then we can take the public comments on the subsequent section. But I don't want to cut you short, but I do want to address another issue that's come up by some of the requesters or some of the members of the public who are in the posse.
Okay.
So why don't do you have
You're
anything?
suggesting we take public comment now?
What I'm suggesting is, do you have anything else that's on that narrow section there?
In the narrow section, no. I do have some other concerns with the overall section 67, new 67.20.
Well, let me just raise this one then. There's been some concern by James Chafee, Peter Warfield, and others about the provision modifying the language to set up a custodian of records as a point person. And again, the reason why we adopted that was that we heard from a number of complainants that they would submit a public records request and it would be lost in the agency. The agency would come in and say, well, I don't handle those. I handed it to someone else. They didn't follow up. Or requesters don't know who to submit the request to. There's not a designated person for a department or an agency. So we had a bunch of people who would come up and complain about that. And so we were trying in good faith to set up a system where the departments would have to specify at least one person who would be a central repository for requests, for information, for doing rules and forms, if necessary, for that department or for that commission. So that's why we did it. We've also heard from members of the public who have been subject to a policy where they're required by perhaps the library or the library commission to speak to one person, to speak to the PIO, whoever it is that they've designated, and they've had trouble getting either oral information or readily accessible public information from others in the department. And so they see this as a bottleneck, whereas we were seeing it as something to facilitate open government and to facilitate responsibility and chain of control and custody in the department. So there's a tension there. I see that tension, and I'm trying to figure out what we should do about that. And I know you said you would consider it rec. I didn't know if you had any ideas. But
Well, I believe there's also other language in here stating that, you know, when a custodian of public records, let me see, that, you know, a custodian of records shall, when he or she knows that he's going to be away, for instance, that he appoints somebody to take his place. And also, there is language in here, every person having custody of any public record or public information. I mean, that's the very top of section 67.20. Every person having custody of any public record or public information as defined herein shall, at normal times and during normal reasonable hours of operation, without unreasonable delay and without requiring an appointment, permit the public record or any segregable portion of a record to be inspected and examined by a person. So even if, what I think that says is that even if a person is not officially designated as a custodian of records, if that person has possession of the records, then it's up to that person to make sure that the requester is served. That's how I read that. Member Coughlin?
It also makes a provision in A, line 7. It says the custodian of record shall have identifiable departmental deputies to fulfill this role when the custodian is unavailable. But I know what they're saying about the library, that they would like it if they could just ask anybody and get a response. But here, when in line 19 on page 55, at the beginning of section 67.20, as you say, it's every person having custody, so that would limit. In other words, someone could say, well, I'm sorry, I don't have custody of this record, so you have to go to the custodian of records or their deputy.
Well, I think also that when there is language in here that when a person, an employee or an official, does not have custody of a public record, then it's up to that person to find out where the record is and to assist the requester in getting that record. You know, to direct the requester to where that record is can be obtained.
I think if we hear public comment on this, we may get more ideas.
Okay.
Let me, I did have one idea.
Member Craven Green.
I did have one idea, or one necessary change. I mean, I think your point is right. We kept the language in former A. It's now kind of not a subsection. It's the statement of the initially right beneath the header of 67 new 20. We also kept and hopefully strengthened the information with respect to release of oral public information from anyone who has it. That's still in the ordinance as well. So the only thing we've done is add in this custodian of records here to be the departmental point person. But what I would say is, I think this was an omission in the first paragraph. It's on this is actually on pages 55 through 56 of today's packet. It should be to be inspected and examined by any person and shall furnish one copy thereof upon payment of the copying charge, because we specify the cost later, so we don't need that language. I think we went too far by accident in striking that. So it makes it clear that not only, if you go up to someone and you know that they have a record, and it's possible for them, it's non-exempt information, it's possible for them to copy it right away and give it to you, and we're talking about records that don't have exempt information, and records that they don't need to consult the city attorney about, but those records should be copied and produced right away. So, I mean, I agree that
You want to add that back in?
I would want to add that language back in, correct.
Okay, and where is this now? Which section?
This was on bottom of page 55, going to top of page 56, 6720A. Or any segregable portion of a record to be inspected and examined by any person, and shall furnish one copy thereof upon payment of the copying charge. Because otherwise, it only allows for immediate review, right? And that's not what we're saying. What we're saying is these folks should be able to get those types of documents without unreasonable delay.
Okay, since that's substantive, that also comes in the form of a motion. There are a few other things here.
I think we've kind of gone, can we limit it to that and take public comment on the issue of the custodian of public records and of the how long they have to set aside documents? Because those are two kind of substantive things. If people
Yeah.
want to comment on those issues on the task force, let's do it. But otherwise, let's have public comment, and then we can turn to other issues.
Okay, what I'd like to do then is take these two motions. It's probably a good idea to take these two motions separately. First, let's go first with
Well,
Pat.
why don't we hear public comment first, and then we can separate them out? Public comment is to both? It's up to you. Rick.
Well, usually, I think the way it goes is we take public comment on motions once a motion is made. So what I would ask is, it's been moved to reinstate the language start at the bottom of the paragraph. Would be new 67.20 with there's no A in there. And shall furnish one copy thereof upon payment of a reasonable copy charge not to exceed the lesser of the actual cost.
No. It's just upon payment of the copying charge.
Okay.
Because language about cost of copies is specified elsewhere. We're trying to streamline, not duplicate.
Okay. Is there a second?
There is a second, I'd second.
Okay. Moved and seconded, and now we'll ask for public discussion on this particular motion.
Or on the issue of the custodian of records more generally.
I'm sorry? There are not many people here in the audience today, so let's set a time limit of 5 minutes per speaker.
We only have half an hour.
Please bear in mind that the meeting may be adjourned early, so if you can limit your comments to faster than 5 minutes, it will be helpful and appreciated. But since there are so few of you, we want to be accommodating and flexible.
Thank you, Mr. Chair. Peter Warfield, Library Users Association. First of all, I had hoped to be out of here by 5:15 or so. I do have something else that I need to go to, and I had hoped that there'd be public comment so that people could make general comments about all aspects that you're taking up today without necessarily having to stick it out to the bitter end or go through section by section. With respect to the discussion that I've just heard, I'm both pleased by some of your concerns that all of the members speaking have expressed, and I'm also very troubled by a number of issues. And with respect to this section that we're specifically talking about here, it needs to be crystal clear that every person who works in a place, and what does it mean, custody? Anybody who's got possession of or access to any public record or public information has the obligation to do these things. Now, the problem with the next section, A, is that it sounds as though all of the preceding is subject to all the little details and procedures and requirements and forms and every other obstruction that a custodian might design. And we have a very good example if you look at the library's procedures, which in this body, there was an attempt to change because they were in many ways violating the ordinance, and that attempt failed, sadly, under a body quite a number of years ago, under a different chair and with quite a few different members, and the story of that is something that I and another member of this body certainly would remember, at least one. But it sounds as though the custodian can weave an entire web of supposed streamlines and procedures and forms. I go to a library branch and I see the circulation records year to date and this month for June for all the branches on a single sheet, as I have done with a colleague of mine on the Library Citizens Advisory Committee, and I don't want there to be any question that the librarian who's got that in his or her desk and who's showing it to us has any business saying, oh, as for copies, why don't you go to the chief of branches? And now my poor colleague on LCAC has to try and figure out who is the chief of branches. How do we get in touch with that person? When do we get in touch with that person? Where do we get that stuff? How do we get it? And that person, in fact, it was weeks and weeks and weeks before that person, in fact, ever did follow up, when we literally had in our hand a one-page document that should have been a requirement for the person who showed it us. Just make us a copy. There's a flaw here that there's nothing anywhere in the ordinance or here that says when must copies come. Yes, a reasonable time, no unreasonable delay, blah, 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 blah. But in this ordinance, you come naked when you ask for a copy. Immediate disclosure request, they got to give it to you by the end of the next business day or have a reason. Copies, you're totally at their mercy. And I think that that's urgently required. I described briefly some of the games that have been played with respect to costs. Let me tell you, since you didn't have private, secret meetings with me, but evidently, according to Ms. Craven Green, there have been all these discussions with all these departments, which I'd like to know when they occurred and were they done in public, so that the rest of us could hear what these complaints were about how they had so terribly long to leave the documents out, blah, blah, blah. And I would like an answer to that question, but the key here is that you've heard it from the departments, but you haven't heard it fully from us. So let me tell you, the games that departments will play about costs and about the calculation of costs are enormous and can be tremendously delaying and time-consuming. I can't give you these 8 pages today because I've got to get the money for it first, and, oh, I can't take your cash because the other office that handles that is closed, or I can't make change because I can't change a 20. Oh, you've got $1, I can't change that either. Oh, you've got 80 cents, I can't give a receipt properly for the money, so I can't give you the copy right now. And by the way, if it's anything that's more than a few pages, I also have to have you come in to pay for the postage, because I have to weigh it first after making the copies so I can know what the postage will be if you leave now and I send it to you. No, I can't send it to you because first you've got to pay for it. So the whole issue of costs and when is the cost and what is the cost and the promptness of copies and whether payment has to be received in advance is a giant kludge that departments use to delay. And you guys need to hear from Posse and everybody else that I've told you need to hear from about the games and the problems that arise from the smallest thing, which you look at and may consider to be in a normal course of events. Sure, they make me a copy, and thank you very much.
Thank you, Mr. Warfield.
So this needs a
Warfield.
lot of work, and so
Mr. Warfield.
does the rest of this thing. It's not ready to
Okay,
go
Mr.
out of
Warfield,
this
you've
body.
had your 5 minutes,
Thank
please.
you.
Thank you very much. One of the questions you have does, I think, bear a response, and that is, when did we have all these meetings and discussions with departments? After our last package was subverted by certain members of the Board of Supervisors, we went back and queried a number of departments. Some of them did appear before us in public. Some of us submitted comments in writing in response to a form that we had sent them. All of these are matters of public record. We have done absolutely nothing in secret. Your concern is valid, sir, but we have done absolutely nothing in secret. Please be seated. Please proceed, sir. Please proceed.
This is public comment, right?
Yes, I'm asking for public comment, so please proceed.
On the,
Oh,
on,
I thought you said, please be seated.
Oh, no, I'm sorry.
I'm going, oh, okay.
Well, I need to improve my pronunciation, and thank you. Please proceed with your comments.
Ray Hartz, and I would like to be notified when I reach the 1 minute point, please, if I do. I have one general comment to make. I really do think when you're going through this, you should have an opportunity for general comment, because there are two things going on here. One are the content changes, the actual changes you're proposing to the Sunshine Ordinance. The other is the process by which you do it. And I think that it is equally fair for someone to have in general public comment an opportunity to raise questions they have about the way the procedure or process is being handled without having to worry about being cut off when they try to slip it in the comment on this general section. But on this general section, the whole idea of having the point person, I think, is a very valid one, because when I go into a public office, if I ask a person who is a custodian by benefit of the fact that they are there and are an employee in that division or office, should be able to give me copies or allow me to review any public record that they have access to. And unfortunately, what my experience is that's not what it is. It becomes oh, they aren't here, I can't help you, so you'll have to come back when they're here. So it is a way to delay doing it. I have also had experiences where a person who probably didn't know they weren't supposed to tell me certain things told me those things, and then later on got slammed by their supervisor because they didn't know they weren't supposed to tell you certain things. And I think, unfortunately, this leaning on an administrator, a particular person in the department, leaves a lot of openings for delay, and especially if it's some sort of a record which the department or the agency might not want you to see, for them to go through and review what's there and hold things out. And as we've seen with the planning department, say, oh, well, we don't have that. And then you find out later, well, yeah, they did have it, they just didn't, well, we missed it. Okay. Very frankly, when I go into a department, if I ask someone for a record, a public record to review, or a public record for which I want a copy, if they are telling me they can't help me, I will then ask to speak to this other person, and we now have two issues. Issue one is, where is the document that I'm asking to review or get a copy of? And secondly, why is it that your public frontline employee, who you were responsible to see understands the Sunshine Ordinance, is not able to answer public questions? Why is it that I have to come in here and go through 2 or 3 people to finally get to the point where a public record, which should be pretty clear to understand, is in my hand? The reasonable opportunity thing, unfortunately, using words that are just so general like that, reasonable. What's reasonable to a person may not be reasonable to the city agency. My experience, again, I went to the Library Commission meeting this last time. Before going to any sort of meeting, in order to be effective in what I want to do and to not waste anyone's time, I review minutes and I review proceedings from prior meetings. Unfortunately, their system was set up in a way that I was unable to find the information, and so I really couldn't do the job that I wanted to do. And really what happens is, my experience has been, again, if controversial issues are coming up on a particular meeting, it behooves the agency to withhold any information they can till the very last minute, so that you have to show up at the meeting, pick up the minutes, and you go, oh my God, look what's on the minutes. And you don't have any time to research it, you don't have any time to plan what you want to say and to get it out. So really what I'm seeing is a lot of this really turns out to be things which allow the agency, as I've told you in the
One
past.
minute.
1 minute? Okay. It is a very, very long-form application for a public record, access to it, or a copy of it. And this is really, you have to keep in mind something that the common citizen, the average person, needs to understand. And this is such a large thing that even even you and members of the public, like on the Sunshine Committee, have to read this over and over and over again. In fact, I've had a couple of those people tell me they weren't going to comment on this because they didn't have time to go through 110 pages of changes. When are you going to do something to allow the citizens of the city to have a reasonable chance of working with these agencies and getting them to just follow the law? Because bottom line is, I think every one of us knows there are people in every single city agency here that simply will not follow this because they feel it's a waste of their time.
Thank you. Is there further public comment?
We're talking now about 6720, the new 6720. As I understood it, you were going to take public comment on each of the subsections, but it doesn't sound like that's what's going to happen. So let's talk about A, which starts on line 3 of page 56. The last second sentence, each custodian record shall have written procedures and forms to streamline requests, assist members of the public who request public records and information. And then in B, you have to submit basically a written request for a copy to the custodian of records. When you go into the planning department and ask to see a file, first, they don't make it available to you immediately, so you have to give them at least some advance notice you're going to show up. When you do show up, they have the file, but in order to get it, you have to fill out a form and leave your driver's license. Surprise? Where's that in the ordinance? Every department has a PIO or similar person who stands in the way of a person who seeks a record from getting the records. Department of Public Works has Frank Lee. Brian Smith in the DBI, he stands in the way. No, he's in planning. There's a young woman in DBI who stands in the way. In other words, you've got to go through their procedure whether you want to or not. And this creates a problem because once you get to that person invariably knows nothing about the content of the records. So if you want to follow up for additional information, you're at sea. And that person is often the person who appears before the task force. You have this emptiness that's involved. Also, requiring a form to get a copy of a record means that the requester has to give his name or her name. And as I understood it, you never have to do that. So this whole business of setting up a procedure in advance that has to be reasonable, from whose point of view, you got lots of comments from the departments because they would love to slow everything down. As it is today, there are departments who have 10 days to respond to a public records request, up to 10 days, and always take 10 days, whether they got that record in 2 days or 3 days, and whether you ask them to provide them on a rolling basis, they always delay. So everything that you put in that gives them an opportunity to do that is going to make it that much harder for the public member. So I would go just opposite. I would insist they give it to you as soon as they have it, okay, even though it says, and say if it's going to take longer than 3 or 4 days, they have to give a reason. And as far as having a custodian of records, I think that's a huge mistake. Thank you.
Thank you. Is there further public comment? Seeing none, public comment is closed. Matters back with the task force.
I had
Member
a question
Coughlin.
for Mr. Grossman about the driver's license requirement. Mr. Grossman? I have been asked for a driver's license, but only when they give me original plans. Did you get asked for a driver's license on simply a routine request?
I asked for the plan submitted by a project, an owner of property for a project on that owner's property.
So you were looking for a look at the plans?
I wanted to look at the
Yeah,
plans, yeah.
Yeah, my impression, I'm down there a lot, is that they require a driver's license when you look at original plans, because they're afraid you're going to walk off with them maybe.
Well, DBI will let you look at original plans without a driver's license.
But they won't let you copy them.
Pardon?
They won't let you copy them.
Well, they have copies. The architect gives them 2 copies at least. So, I mean, why are we having this discussion? They have no right to ask for my driver's license. If they want to have somebody sitting there while I inspect the record, fine. But what if I don't have a driver's license, which I tell them I don't have? You know, do I look like somebody who's going to walk out
Well, I'm
with a
just
set of
telling,
plans?
want to say that this is their policy, and they've done it to me,
Look
too.
like somebody who will walk out with a set of plans? Thank you, Mr.
Yes.
Copeland.
We all do.
We all do.
Further public comment? I'm sorry, further discussion from members of the task force.
Can we make a
member-
roll call? Oh, sorry.
Member Washburn.
I was listening to Peter Warfield's suggestion for a wording change for the paragraph right under the heading section 67.20. And I think it was a good one. Right now it reads, every person having custody of any public record or public information. And somebody reading that might think that that's some sort of an official duty to have custody of that record. That sounds like that would be a special job duty. And what we want to be saying is that anybody possessing or having access to any public record or public information, that was the wording I heard Mr. Warfield mention in passing, but I grabbed onto it because I think that would be a way to emphasize that any city employee that has access to something has a duty to provide it to a member of the public who requests it. I think having the word custody in connotes this has to be part of their job duty and so forth. And that would give an out for a regular employee saying, well, you know, it's not my job to manage these records. Yeah, I use them all the time. As a matter of fact, I have one in my hand, but it's not part of my job description. So you have to go speak to my boss's boss. So I'm wondering if that wording would help.
Would you like to make that a substitute motion or a friendly amendment to the motion?
Friendly
May I
amendment.
address it first?
Member Craven Green?
The problem with having access, everyone, I mean, I potentially have access. For example, someone comes in and says, I want this, document that's, 3 offices away. Well, I mean, I have access to it. I'm allowed to go, 3 offices away and ask them for it. I think it's too fungible, right? What does access mean? What's the definition? Immediate access, access in 2 days. I would say possession and leave it at possession.
Possession, okay.
If your concern is that custody sounds too legal and implies something, then I would just say possession. If you have possession of it,
Possession or maybe immediate access, would that make sense?
Well,
Member Wolf?
the problem with immediate access is it doesn't necessarily mean that they're the custodian of it. It means that it's sitting up on the wall on somebody else's desk. It's immediate access. The question, the way the law is written is you're applying to the person who actually has the document, works with it,
Okay.
and is in custody of
Right,
it,
right.
or possesses
Possesses,
it.
okay.
Right. That's the person. That's where the request is being made to that particular custodian.
Okay,
So immediate access would just mean then why bother having custodians? If anybody has access to it, then they should give it to you. You can ask anybody, which could make it a little more, I don't know, complicates things, I
Sure.
think. But here, people want, you worked on this document, fine, I want a copy of it. If I have any questions, I get to come back to you and ask you questions about the document you are working on or that you have in your possession versus somebody who may not. That's a rationale.
Okay, then I'd like to, my friendly amendment would be to have the wording be every person possessing any public record or public information, or every person having in his or her possession, something like that.
How about having possession?
Point of
Every person
information.
having possession.
What page, what line?
I don't have the recent version.
Page 55, line 19.
Yes.
Okay, this is under
The beginning of 20.
the beginning of 67.20. So having possession of is the wording we're using?
Yes.
Okay, is there a second to that amendment? Second. Okay. Maker of motion, maker and second accept?
Yes.
Friendly amendment, good.
Question?
Member Wolf?
Does that change any serial or any additional replication of that term throughout the document? Will all phrasing regarding every person having custody or any custodian having custody or any entity having custody, will that have to then be changed throughout the entire document?
Should.
Well, here's the question. We've defined custodian of records in A, and that's a specific term. So we don't change that.
A.
And D,
Oh,
custodian of public
sorry.
records. So I'm not sure it does.
Okay.
Except perhaps in F, where we don't call him the custodian of records, we call him custodian. F might be the one place that
You know,
F and G.
I just have a little concern. I mean, I really would have liked to have, again, we're missing a DCA here. And I really would have liked to ask a question, and I'm sure Member Craven Green can answer it too, is whether the word possession offers any additional ramifications, or is it exactly the same as custody? Does it increase or decrease the gravity or value? I mean, I would like to have some counsel here to be able to bounce some ideas off of, or, you know.
It should be fine. I mean, it should be the same. It's basically this, in the way it's used in this ordinance, it would be the same parlance, the same effect as custody.
Okay. My additional concern would be,
It might be, I take it back, it might be a little bit broader. So for example, if, for example, certain people have a custody of a document that's being edited by multiple parties.
okay,
So custody could, I guess, be interpreted as applying to that one person who has custody of it, whereas 5 other people might have possession of it.
Okay.
So it's technically, it could be a little bit broader, but I think by and large it's coextensive.
okay. Then the only concern I have, Mr. Chair, is without a DCA sitting here, after we're done with this and we finally get to our last meeting on the amendments, and this then ends up at his or her table, are they then going to reverse a bunch of stuff that we've done because they haven't been here to help oversee or at least counsel us in certain process?
Well, first of all, this would not go directly to a deputy city attorney. We plan to take this through certain members of the Board of Supervisors.
Right.
They will look at it, and those supervisors who want to sign off on this will then take it to a deputy city attorney or to the city attorney's office
Okay.
for approval of form, as to form and content.
Okay, my concern is that without having a DCA here, then that will be the first time then a different DCA that is outside of the firewall, the ethical firewall that we sit in here, will then have an opportunity to make any kind of opinions that are not within the pleasure of this august body. So I'm inclined. I'm a little concerned because this is now my third meeting and I haven't seen a DCA here in an official meeting of this board. I've never been at a meeting without a DCA sitting here. I think it's really, I think it's unconscionable actually, because it's a requirement under the law. So I'm a little concerned right now, to say the least, and I would move that we do not finish approval of this until our DCA has reviewed everything that we've done and offers an opinion on many of the things that has been done before my presence here in this term and up to this point.
Member Coughlin.
On that subject, I just want everybody to know that in the Education and Outreach Committee report, we did mention that not having a city attorney at our meetings is a deficiency. I wondered if Member Nee could review for us the reasons that we are not having a city attorney at many of our meetings and
Well, it's a matter
what
of-
the standards are. We know it's money. If you could
Well,
just give us
that's it,
some
it's money.
idea, if you could just give us some idea of what the standards are for having an attorney at meetings, a city attorney.
Well, the deputy city attorney is limited. The deputy city who is assigned to the task force is limited in terms of the number of hours that he or she may spend per year, per fiscal year, on duties relating to the task force. And so, in Mr. Threet's case, he has decided to limit his participation here in order to come within that limit. And I think what he's decided is that where his services are needed to interpret and help the task force to implement the Sunshine Ordinance and to apply it, particularly when it comes to complaints, I think that's going to be his priority.
Just wondering
Priority.
how that dovetails with the requirement in the ordinance that we have a city attorney whose full-time job is to be an attorney for the task force.
Well, the ordinance is fairly clear, but the city attorney's office has made it very clear that there are budgetary, even though I can't pronounce it, budgetary constraints there. And, you know, I think probably the only way we could override that would be to maybe get the Board of Supervisors to assert itself, to interject in our behalf, or take the matter to court. But we don't, again, there's a question of whether one city entity may sue another entity within the same city. I don't think that question has been answered. And we might, if we tried it, who knows where that would lead. We would have to find an attorney to represent us, and we don't have the authority right now to hire one. So, we're dealing with, I guess, a great deal of catch-22 here, but right now, I just don't see what we can do to remedy the situation. Member Cawthon?
My thought would be that that requirement of a full-time attorney was voted on by the citizens of San Francisco. It didn't say only if there are no budgetary constraints within the department. So maybe when we visit that section of the new ordinance, we could insert a phrase saying, regardless of any departmental budgetary constraints.
Okay, thank
I
you.
won't be here when you get to it,
Okay,
but
thank
that
you.
would be my thought.
Well,
I
Okay,
think some of
thank
us
you.
will
Member-
propose language to that effect.
So I'm sorry, yeah, I digress, Mr. Chair. Is the motion just to add the word possess, or is it for
Well,
the
this-
whole section?
Well, first of all, there are two things here. Number one, to replace the words custody of with possession of, or replace the word custody with possession. And number two, at the bottom of that paragraph, the crossed out, most of that crossed out language would be reinstated, and shall furnish one copy thereof upon payment of the copying charge, period. Okay, and I think we're ready for a roll call on that.
On the motion, Member Craven Green.
Aye.
Craven Green, aye. Member Cawthon.
Aye.
Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Wolf. Wolf, aye. Member Chan.
Aye.
Chan, aye. Member Goldman.
Aye.
Goldman, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 7 ayes.
Right, and we usually do it by, well, we don't usually do it by motion like that. We just use it without, unless there's going to be objection or dissent. I'm just saying that's been our practice to date. To the chair, for however you want to do it, it just might be very burdensome going forward to do it in this manner. I'm assuming that the suggestions you've made to A already, adding an S and taking out an S, are without objection?
Yes.
Okay, without objection?
Without objection.
So the next is C2.
Correct. Member Craven Green, I believe, had suggested adding language at the bottom. The custodian of records shall be required to set the records aside for review for at least 14 days, unless agreed to between the requester and the custodian of records, but in no event shall the custodian of records be required to set the records aside for more than 14 days. Do we want to specify calendar or business days in that?
No, it's going to just be 14 calendar days.
Okay. 14 calendar days. We have not had public comment on that particular item yet. Is there public comment on this provision and on this amended language?
Before you go, Mr. Chair, just a point of information. I'm not understanding the point of the amendment. Are you saying that you want to limit it to 14 days?
Well,
You want to turn this sentence on its head?
Well, first of all, earlier, Mr. Warfield pointed out that there is no minimum requirement in terms of how long a record needs to be set aside for a member of the public,
Right.
and that a minimum should be established.
And that's what you're seeking to do?
That's what we're seeking to
Okay.
do.
Okay.
And the minimum and maximum would both be the same.
Okay.
Okay? Sir?
Actually, I'm confused. If I have a right to walk in and inspect a public record, and the person at the desk says, you have to see the custodian of records, because I don't know anything about that record, what do I do? Oh, the custodian records is at a meeting and won't be back until 4 o'clock. What do I do? Or the custodian of records says, well, I'm not sure where they are, and I'm only required to afford you a reasonable opportunity to inspect those, so come back the day after tomorrow. I should have them at 2 o'clock. And I say, well, I can't make it at 2 because I have one of my many doctor's appointments. So you get into this game, and that's actually happened to me. And I don't see the point of it, to be honest with you. This custodian of records is a way in which departments and agencies delay the opportunity and give you as much heartburn as they can. DBI, I wanted to inspect some plans for a project on 27th and Fulton, and I was informed that all of the plans for a period of years, were unavailable because they were sent out for scanning and they didn't know when they'd be back. But they'd put in a request for me, and maybe I could see them in a week and maybe not. So, you know, you get caught up in this bureaucratic snarl. And all this does, when the minute you use the word reasonable, unreasonable, you're looking for trouble if you're on my side. Because what am I going to do? Go to the task force or the commission every time I'm delayed 3 days or 4 days unnecessarily or inappropriately? No, you've got to make it a bright line, up and down, sideways, top and bottom. Otherwise, the requester is going to have a serious problem. The other point I want to ask is, how do you make a copy of public information? Because that's what A says. Every person having possession of any public record or public information shall allow inspection and shall furnish a copy of it. Public information is the content of the document, or it can be given orally. So there's a real issue as to whether that actually can be functionally executed. I have a number of other comments, but I just warn you, allowing a department or an agency reasonable or unreasonable periods of time is not going to help any requester or person seeking a public record. Thank you.
Thank you. Is there further public comment on 67.20C2? Seeing none, public comment is closed. Without objection, the new language will be...
I have an objection. I need
Member Wolf?
to hear the exact language read back that you're amending.
Okay.
'Cause I don't
In the
s- I
final,
don't have it.
in the final, in the final sentence.
Yes.
And I think I'm correct here. In the final sentence of that section, the language is to read, "The custodian of records shall be required to set the records aside for review for at least 14 days,
14 calendar days.
14 calendar days, thank you, unless agreed to between the requester and the custodian of records. But in no event shall the custodian of records be required to set the records aside for more than 14 calendar days."
That doesn't make sense to me. If it's at least 14 days, then how can it be no more than 14 days? That means exactly 14 days.
That's correct.
So why not just say that?
We're setting...
But the minimum and the maximum is the same.
That's right, but what this does is say that if somebody requests access to a record, they have to hold it for at least 14 days.
But-
And once that 14 days is up, they can also put it away.
So then just say that. But if you're saying at least 14 days, unless agreed to between the requester and the custodian, but in no event shall, why not just say 14 days? No, you're saying it in, you're saying.
Well, we're saying it twice.
You're saying it twice.
Yeah,
and
that's
that's
true,
confusing
yeah.
for the public. I mean, I would just say, if you want to say it that way, I would say, in no event shall the custodian of records be required to set the records aside to review for no longer than 14 days.
And that doesn't set a minimum. The language you just
No
suggested.
longer than 14 days. The minimum is the day of request. From the day of request to maximum of 14 days. That's
Well,
it.
A lot of times the records aren't available on the date of request. They have to be compiled, and then once they're compiled,
So then from that day, I mean, it's.
say it again, Bruce. What your position is?
My position is that you should just say that it's exactly 14 days.
Use your language.
What say it? I don't understand what it is.
Oh,
They
what
should
my
be-
language should be? Okay, in the event that the custodian shall set the records aside for review for no longer than 14 days.
Well, that's what it says here, but that...
No, it says for longer. Here, it's in the positive. In no event shall the custodian of records be required to set aside for longer.
That's an
Oh, that's the maximum? Okay. Okay, this is the key word. Okay, in no event shall the,
No event's been stricken from the proposal at hand.
in no event has been stricken?
Yes. So the first in no event, the second in no event is still there. It reads, "The custodian of records shall be required to set aside records for review for at least 14 calendar days, comma, unless agreed to between the requester and the custodian of records, comma, but in no event shall be required to set the records aside for more than 14 calendar days."
All right.
So you're starting a new sentence there on line 7?
Line 10.
Where
Well,
are we?
continuing the sentence on line 10.
I'm going back to line 7. It says, without requiring an appointment or at another time convenient to both the requester and
No,
the
that's not where we are, Ms.
I
Member
know
Coffin.
I'm trying to get to where you are.
Where we are is
Can I please
where we are is the final sentence in that paragraph.
Right, and that begins on line 8. The custodian of records shall be required.
Right, to set the records aside for review for at least 14 calendar days.
But in no event shall be required. That's the operative word, to set them
Where
aside.
are you starting that sentence?
Line 8, the custodian of records
Okay, you took
shall
out
be
in no
required.
event.
We took out in no
You
event.
took, okay.
Oh, you removed in no event.
Correct.
So it starts capital C, custodian of records shall be required?
The,
The,
The.
capital THE.
Okay.
The custodian of records shall be required to set the records aside for review for at least 14 calendar days unless agreed to between the requester and the custodian of records, but in no event shall the custodian of records be required to set the records aside for review for longer than 14 days,
But you are
or more
repeating
than
yourself.
14 days.
At least 14 days means the same thing
Okay.
as no longer than 14 days.
Well, no, it doesn't, because the custodian of records could still have the option of leaving it leaving it out there for longer than 14 days, if they
I
reach
hear
that
you.
agreement.
I hear what you're saying.
But the requester could then not say, could not require it for longer than 14 days. And there are certain considerations for that on that.
I'd like to hear why. Why set a maximum?
Because they may need those records on a day-to-day basis, and they can't have them tied up, sitting around for someone who doesn't come around in 14 days.
But
They need to take those back and put them into work.
we heard that from a number of departments
Okay.
3 years ago when we had hearings, public hearings.
I'd hate to
Okay.
bring this in at this late date, but I would prefer saying business days, only because it makes it 2 solid working weeks. Otherwise, we'll have the same problem that Mr. McIntyre referred to in when minutes are being posted, or when agendas are being posted. You could have Saturday, Sunday, then 5 days, then Saturday and Sunday. That's 9 days. So it seems to me that if you just say business days, you'll very clearly have 2 weeks, 10 working days to get the documents.
I think
That's
the
what it
idea was
means.
14 days was 2 weeks, 2 calendar weeks, and
Yeah.
that's why we put calendar days.
It depends on where they start.
Oh, that's an interesting point.
What do you mean?
Let's say the
It would be the same number of days no matter when it starts.
14
Well,
calendar
it might not be
days.
the same number of working days because
Yeah.
of holidays.
The
You're
calendar
right.
days-
You're right. There
The
could
calendar days
potentially.
include Saturday and Sunday.
Correct.
Working days do not.
I clearly understand that.
Well, should we substitute 10 business days?
And
Yeah.
10 business days is the same as 14 calendar days, except in case of a holiday, right? And then you're talking about one less. Otherwise, it's the same. Right? So, if
Splitting
people,
hairs, and there's no need to.
Well, we are splitting hairs, yes, but some people do have some preferences there. I sense a strong objection to 10 business days rather than 14 calendar days. Is there a strong objection to 14 calendar days? Then I would suggest leaving it 14 calendar days. and moving on. What I would like to do at this point, and Mr. Clerk, please, are you up on our language? Leave 14 calendar days in, and let's move forward from here. What I would like to do now is go a little bit out of order, maybe a lot out of order, and jump. We don't necessarily have to act on it now, but I would like to jump to new section.
All right, Mr. Chair, I just a point of process. I did not, did you ask for any objections?
I'm about to.
Okay.
I would like to jump ahead, just not necessarily for action, but for discussion's sake, to new section 67.34 about the commission. This is old section 67.30, and there is a specific matter that I want to bring up here. It has been suggested by certain people, some on the task force, some in the public, that that the size of the task force be reduced, and B, that New America Media be removed as a nominee for seat number 4, as the nominee for seat number 4. The reason that I would like to discuss this now is that the executive director of New America Media is with us right now. She would like to explain to us what New America Media sees as its role vis-a-vis the task force, why New America Media wants to be part of it, part of us, and why this interface is very important to New America Media. And without objection, I would like to invite that person now to the podium, invite her to speak, then invite additional public comment from others in the audience, and then we can either discuss it among ourselves or move on. Is there objection?
I still, a point of process. The previous item we were just discussing.
There was a
did you-
motion pending.
So it's a motion, so we're taking a break from that motion before we,
Well, no, we've moved it forward without objection.
why? That's what I asked. I did not necessarily hear that because I do have an objection. That's what I was, my point of bringing this up was.
Okay, so,
And I don't necessarily agree with the addition to that particular sentence.
Okay.
I don't think there should be a limit.
okay.
So we should need roll call.
I think we need a roll call vote on this. So would someone like to make a motion that this language be adopted?
So moved.
Moved, is there a second? Moved and seconded. Is there any further discussion?
No.
Roll call, please.
On the motion, Member Craven Green.
Aye.
Craven Green, aye. Member Cawthon. Cawthon, no. Member Washburn.
Aye.
Washburn, aye. Member Wolf.
No.
Wolf, no. Member Chan.
Aye.
Chan, aye. Member Goldman.
Aye.
Goldman, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 5 ayes and 2 noes.
Okay, the motion fails.
All right, well, before we move on, I would just like to point out to the people who just objected that all we have there is a 14-day minimum now. So you have to suggest something.
So I'm going to
Yeah.
suggest that it be 30 days.
Okay, when you say it, are we talking
We're
about?
talking about if you want to create a maximum, then I would suggest that it be 30 days.
Stated in the language that you want to see added to the ordinance.
So the custodian of records will be required to set the records aside for review for at least 14 calendar days unless agreed to between the requester and the custodian of records, but in no event shall the custodian of records be required to, was it retain?
To
Set
keep
the
the records
records
aside for review.
Aside for longer than 30 days.
Is there a second? Moved and seconded.
Is there not public comment on a new motion?
There will be public comment on the new motion, yes. Thank you for asking. I will call for that now, as a matter of fact, and then we will have discussion among the task force.
I think this custodian of records provision, as I indicated, is fraught with problems for the average person in the public. I do think that 14 days is probably plenty of time for anybody who really wants to see them to get to see them. But accidents happen, I can speak to that personally. So the worst thing that would happen is somebody comes back and asks to see the public records. I think the vice in the section, as I told you before, or tried to explain before, is allowing the custodian of records to determine what a reasonable opportunity is. That's the problem that I see. And trying to get a convenient time agreement between the requester and the custodian record is always going to be a problem. Take my word for it.
Thank you. Is there further public comment?
Good evening, Ellen San. I have one question I'd like to ask. What's the reasonable time in your mind? You know, to me, reasonable time is a couple of days, but to the departments, we ask the record form, it's a limited time, wherever they wanted to give to you. So I would like to have the time frame. Was the law says, what is the reasonable time? Have the days. Just like you said, hold the record 14 days, and everybody understand it. And I agree on that 14 days too. If they need more time, they can ask him for it again. But reasonable time is what time? How many days? What's unreasonable? Is it 1 month, 2 years? So I would like to know. Some document in the past, we're asking takes about 9 months. You don't believe that, but it's true. So when one proper record I requested, they do have that. They asked me for the particular day, particular time. I was working. I said, I cannot do that. For one document to review, they have to ask the deputy director, 4 high officials to be there. I said, if you wanted to watching us to review that, you can have a club. We have nothing there. So it's okay? No. You have to come particular client. Email have been 5 times just to make that appointment. So I don't know what's reasonable time in the board members, in the Sunshine members' mind when you make the law. I would like to know. Thank you.
Thank you. Further public comment?
Yes, I'd like to agree that reasonable, when you use the word reasonable, my time reasonable could be 1 day, your time reasonable could be 30 days, the department's time reasonable could be 90 days. It's up to interpretation by the person who wants to use it to their benefit. And that's all I want to say. Thank you.
Thank you. Is there further public comment? Seeing none, public comment is closed. Task Force? We have a motion and a second on the floor. Without further discussion, we have the roll. Yes, the motion would replace the current language with the custodian of records shall be required to set the records aside for review for at least 14 calendar days unless agreed to between the requester and the custodian of records. But in no event shall the custodian of records be required to keep the record available for review for longer than 30 days, 30 calendar days. May we have the roll call, please?
On the motion, Member Craven Green.
Yes, so we can move forward.
Craven Green, aye. Member Cawthon.
Aye.
Cawthon, aye. Member Washburn.
Aye.
Washburn, aye. Member Wolf.
Yes.
Wolf, aye. Member Chan.
Aye.
Chan, aye. Member Goldman.
Aye.
Goldman, aye. Member Nee.
Aye.
Nee, aye. Mr. Chair, we have 7 ayes.
Okay. Now, without objection, I would like to jump ahead to new section 67.34. We may very quickly lose our quorum here, so we might not be able to have a vote on it at any way. But the question has been raised, number one, on the size of the task force, and number two, on whether New America Media should keep its position as a nominator for seat number 4. I have invited the executive director of New America Media here to address us, and if she would step forward now, please. This is Sandy Close, whom I have known for many years, and we've worked side by side on a number of occasions. Ms. Close, please Please tell us about what New America Media is and why you feel it's important to maintain this relationship.
Sitting and listening to the discussion, it just struck me what incredible dedication it takes to do governance, and the dedication of time, thought, understanding of the processes of governance is, I think, very impressive. I sat and listened and in no way felt bored. I actually was surprised. I was just very impressed by the process. I think as journalists at New America Media, we are very struck by the growing challenge of government communicating with the governed. As media melt down, as the whole infrastructure of communication changes, we're more and more asked as a organization that has the trust of ethnic media to bring ethnic media together so that agencies of government like the Centers for Disease Control, like the US Census, like the FDA, can ensure that they are getting their messages out effectively to the diverse audiences that are served by ethnic media. I'm not sure we do justice to the challenge, but I think we're more and more aware of how great the challenge is. And from the very start of the Sunshine Commission, we felt honored to be asked to have representation for ethnic media on your panel. In 2000, we finally convinced City Hall to make room in the press office for desks for ethnic media. It took until the year 2000. It wasn't the city administrators, I have to say, it was my own profession. It was mainstream media that didn't want to make room for representatives of, in particular, Chinese and Korean media that were most anxious to be there. So I do think this access that the commission provides for ethnic media, part of your role of keeping the channel of communications, access and transparency open, is symbolically very important for ethnic media. Now, the practical problem is that journalists, practitioners in the sector have huge demands on time. And when we first asked colleagues in the ethnic media sector to take the nomination, it was very difficult for them to commit to time because their assignments often require evening. They're covering community events. They're going to dinners. They're covering City Hall. And we couldn't find anyone willing to take the nomination unless it was someone, and I remember in several cases, two people who really had very clear-cut political aspirations, and we felt were more anxious to promote their own careers than the interests of ethnic media. So in the end, with the support of our advisors within the ethnic media sector, we nominated one of our staff who we would make sure we would make time for recognizing the importance of this work. So Peng Vongs and then Suzanne Manna, both of whom have worked in the ethnic media sector, seemed like a very good compromise. Not ideal. I would love to have someone from the Tsingtao here. I would love to have someone from KTSF or Univision or El Mensahera. But truthfully, especially now with resources cutting way back because of the recession, Univision has just cut a third of its staff. We were really worried about how to maintain the representation that we feel is so important. So our representative, Suzanne Manna, has said she's learned a great deal about governance, and she takes the position very seriously. There are instances when we do have to assign her as a reporter and coordinator to go out of town, and she is now on a month-long assignment in the Middle East. She will be back, and I guess what I wanted to ask was the Commission's understanding of our commitment to the importance of this role and your patience. I don't think we've totally found the perfect candidate in my book who really would be somebody working in the ethnic media, but I also believe we're the best, most neutral, most trusted intermediary to represent the interests of ethnic media on this panel, because we will be sure to support that person and make time for them to attend. Finally, just to underscore again, wherever we can raise the participation and the visibility of ethnic media, that really is our mission. And this panel is a very important part of what we see as fulfilling that role.
Thank you. What I'd like to do, Ms. Close, is ask you to be seated, and we will take other public comment and then throw it to the task force to see if they want to have any questions for members of the audience. Is there public comment? Seeing none, does any member of the task force have any questions for Ms. Close? Okay.
I just want to make a comment that
Member Chan.
I think essentially we do need New American Media, because like she says, this city and county of San Francisco is the most diverse city, and by looking at this board and looking at the demographic of San Francisco, it doesn't show that much of a diversity. So keeping New American Media and having them put a minority in this commission is very valuable.
Thank you. Further discussion? Member Washburn?
I agree with Member Chan, and I think that Ms. Close made a powerful argument for retaining this seat on the commission. I also, whereas I understand where it might be desirable to have a smaller body, given the workload that we tend to have, all the committee work, I think it would be difficult to do that with a smaller task force. Those of us on the task force would be on all the committees.
Okay. Member Goldman.
I don't know who came up with the idea of possibly removing New American Media, but I think it's a ridiculous idea. I don't know who came up with the idea of making the task force smaller, but I think that's a ridiculous idea too.
Well, I think the suggestion to remove New America Media as a nominator came actually from Kimmel Crossman. He said it here in open session, and he's on public record. Ms. Close, could you approach the microphone, please? There is, I think, some concern. Now, first of all, I want to say I agree with my colleagues on the task force. I think it's essential to have an organization like New America Media having as a nominator the function that your nominees on the task force fill, I think, is a vital one. But there has been some concern, I think, on a couple of items, a couple of fronts. Number one, when seat number 4, which is the nominated seat, has been vacant, those vacancies have tended to last fairly long. Number two, there have been occasions, and I think we're seeing it now with Ms. Monek, where the person holding seat number 4 has frequent or prolonged absences. Now, you've pointed out that these people are journalists and they have they have their jobs to do.
The problem that their jobs take them out of the area. But I'm sorry, that's my stupid phone. I thought I had turned it off.
I have to say, in Ms. Monek's case, when she has been here, she has shown, I think, a great deal of sincerity in wanting to learn what the issues are here and in wanting to move Sunshine forward. So,
if I could say this, that I think I've been partly to blame for this. I don't think I got the significance of this seat until I began coming, and that it was, for all of us at New American Media, something of a learning curve. And that's why, to some extent, I ask your forbearance. Believe me, if I thought that we would not be able to carry this forward with a real understanding of the importance of the role, I would let it go. We're maxed out. But I really do. I thought originally, symbolically, it was very important. I think the several commission hearings I've attended, the passion of the speakers, the care and diligence of the members, well, it's very impressive. So I hope you will allow us to continue to participate.
Thank you.
Okay.
Thank you very much. Further comment or questions from the task force? Okay.
Mr. Chair, the
Member
only
Wolf?
concern I have is around quorum, and then the requirement we have for votes. If we can count on a person, and I'm not discounting the organization, but if we can count on a person to be here, and we're next to short to losing quorum, if they're in a consistent state of absence, that it does pose a problem. So that would be my only concern.
Okay. A number of members of this task force have had frequent absences. A number of current members of the task force have had frequent absences for one reason or another. They're valid reasons.
Yeah.
But from time to time, it is going to be a problem. However, since I have been on the task force, and I joined the task force in 2002, our last scheduled special meeting, which was 2 weeks ago today, that was the first time that the full task force, the first time since I have been on the task force, that the full task force has ever lacked a quorum. I'm sorry?
It was last week.
2 weeks ago.
2 weeks ago.
We didn't have a meeting last week.
2 weeks ago, we had a meeting, March 30th.
No,
We had to leave.
Tuesday. Today is the 20th.
Oh, that's right.
Our last special meeting was 2 weeks ago on April 6th, and that was the only time since I have been on this task force that the full task force has ever lacked a quorum for either a regular or a special meeting. I think that's a pretty good record.
Yeah.
So it's going to happen once in a great while, but we move forward and do the best we can, particularly since we are an all-volunteer body. People have jobs and they have families and they have all kinds of things that from time to time are going to keep them away. So, in terms of Member Mane, that's happening to her right now. She's away for work-related reasons, and I think it's valid, perfectly valid.
So, yeah.
Okay. I don't think there's any need for any. Does anyone want to take any action on this now, or do we go back to where we were before?
Correct.
Let's go back.
Okay, we go back to where we were.
I
Mem-
I just want to tell you that
Member Chan,
I need to go.
understand. Okay.
10 more minutes?
Can you stay 10 more minutes?
All right, I'll stay 20 more. Actually, I was supposed to go at 6:30, but I
Well, you
kinda-
had mentioned that in an email to me. Ms. Close, thank you very much for coming and addressing us.
May I? I'd like to get some Mr. Grossman before he leaves, but
Mr.
I do
Grossman,
too.
your presence at the microphone is requested, sir.
well, I think I have some suggestions that I think will be without objection first. On page 58, lines 15.
Which section are we in now?
Just we're
6720.
same one, 6720.
Okay,
This
67.
is F, new F. It says if the custodian refuses, and that should be if the department, policy body, or custodian of records refuses. Just to clear up any ambiguities, making sure that I'm making it broad, so you don't have to get a denial from the custodian of records. If the document never comes and you ask for someone in the department and you don't get it, that's a denial. Same with sub G, which is on page 59. It should read, if the department, policy body, or custodian of records refuses. And I looked at the other sections, and I think that should be consistent. Those are only changes that need to be made with respect to that. So if we could do that without objection.
Any objection?
Also, I'm sorry, I missed this one. There was a, okay, never mind. Those are without objection. The substantive ones are motivated by Mr. Grossman's detailed memo and commentary about the supervisor of public records. So this is with respect to 6720F. And I have two suggestions that I would like to incorporate. I've read Mr. Grossman's memo repeatedly and find it very valuable. What I feel comfortable with, and others may disagree, is the following. On line 17 of page 58, so this is F, sub F. The person making the request may petition the supervisor of public records for termination whether the records requested exist and are disclosable. So it would be for determination whether the records requested exist and are disclosable in whole or in part. As Mr. Grossman points out, sometimes there's no determination as to whether something exists. Departments say we don't have that record. There's an appeals supervisor of public records, and they basically say, well, it's not my duty to go and follow up with the department to see if this exists or how their search went. So that's one change. The other change that I would suggest is on line 22 of that same section, F, the sentence that says, in reaching this determination, I would suggest including, in reaching this determination, the supervisor of public records, insert, may review all relevant documents in camera, which is IN space CAMERA. It's comma, and shall conduct, and the sentence will go on as is. Basically, Mr. Grossman pointed out, Supervisor of Public Records believes they don't have the authority to review records in camera, even though she has done that in the past frequently, but she's not required to, I guess. So this will make that clear that they do have that power and should utilize it. So those would be my suggestions to F.
Without objection?
Mr. Grossman, I would take public comment. Mr. Grossman, before we vote.
Well, you know,
Okay.
I find this whole process rather strange. I mean, you started with A, went to B and C, and now we're over at F. I took the trouble actually to redraft some of these sections in the hope that somebody would look at them and maybe incorporate parts or all of them into what you're now doing. But the problem for me is that it's impossible actually to keep track of some of what's going on and whether all of the concerns that I had been addressed or at least mentioned and either rejected, accepted, or postponed. I thought other changes that I had proposed in F, such as impartial, and also not relying on internal memoranda or opinions of the city attorney that are not published and available to everybody, such things, because that has happened frequently. Paul Zarefsky writes a memo. It's not an official opinion of the city attorney. And then the supervisor of records simply says, well, that's an official position. And then the fight begins because it's not really official, but who's going to take on the supervisor of records? The case is closed. Then you either come here, and then maybe you get lucky and win, and then it goes over to ethics, and ethics says, aha, that is a city attorney opinion, and it is, in our view, it is we always take the city attorney's opinion over the task force. So it's a circle with no end to it as far as the requester is concerned. I know I sound like a broken record. I know you hate to hear me come up here and repeat this stuff, but I don't know how many of you have done as many public records requests as I have. I've requested records from the mayor, from the district attorney, from the city attorney, from the Department of Public Works, from the Department of Building Inspection, from the Department of the Environment, from the Planning Department. And let me tell you, it is not an easy task, and I am trained to read this stuff. I send them letters, I give them analyses and the whole thing, and I just get stonewalled or put through the ringer totally unnecessarily. And anything that is in here that gives them any wiggle room is just going to make it worse. And I think the supervisor of records, as I've said repeatedly, is the place for the requester to go to get some relief. It's the fastest, it's the most efficient, and it should be handled expeditiously and in a fair and impartial way. And it should also reflect the findings of this body, and it should not accept unpublished opinions of the city attorney, which, if they are in conflict with your findings, should have no bearing on what the supervisor of records does. Because a supervisor of records is no longer a deputy city attorney. Supervisor of records is a different person, changes his hat or her hat, and becomes a judge. Thank you.
Thank you. Is there further public comment? Seeing none. Member Craven Green.
If we could have those changes approved without objection. If someone else has additional changes, we can move on to that. But I feel like at a minimum, what I've suggested incorporates some of what Mr. Grossman wants, and we can all agree to it. There may be a dispute as to whether we go further.
I will not object, but I reserve to reopen this at a later time for further amendments.
That's fine. Since you're on the prevailing side, of course, that gives you the option of doing that. Okay.
So, Chris, did you catch those? Okay. All right. Thank you for staying, Hanley. Mr. Grossman's been here, and I know this is something he wanted to weigh in on. So.
Okay. We're still within 67.20. Is there anything else that anybody wanted to? There are a couple of things that I want to bring up, and these are non-substantive. In 67.20D, for D for David. This would be at the top of page 58, I think. I'm going on our last package.
It's 57. D is on, starts on page
Okay,
57.
then it would be at the top on line 1 of page 58.
Yeah.
After the word records, there should be a period. And then on the next line, we've crossed out within and put in within the possession, custody or control. I prefer the word in. I don't know how others feel about it, but I think in the possession of to me it sounds a little sounds better for what reason I'm not sure, but to me it does. And I'd like to change it back to in, if there's no objection.
I'm sorry, where was the S that you took it? You added
Okay, I'm sorry?
Where was the S? Location of records, you said?
Yeah, on page 58, line 1, requester to identify records.
Period.
Period. There should be a period after records.
I know, but I'm trying to do it on one document. Requester to identify records. Where is that?
The next sentence starts if.
This is in
the
section 67.20D, D for David. And it starts on page 57 and continues on to page 58 in our packet, in today's packet.
Okay, thank you. I found it. Thank
Okay.
you. And then within,
And then within, I'd like to change it back to in, if there's no objection.
No objection.
No objection.
Okay. Second, let's see, on page 59, I guess it is, line 5, if the custodian refuses or fails to comply with any such order within 5 days, I'm wondering if we should say 5 business days. Okay. And
where are we?
okay, page 59, line 5. I think we should insert the word business between 5 and days. This is in 67.20 F for Frank. If the custodian, page 56, or 59, I'm sorry,
Okay,
line
thank you.
5.
So 5 business days? is what
5
you're saying?
business days, I would recommend that. And then also on line 9, instead of ensure compliance, ensure with an E instead of an I.
Can you clarify the difference in definition?
Well, to ensure
It means to
is
get
sort of
insurance.
to protect or to
Okay.
to ensure means to make sure. In 67.20 G, line 16. This is still on page 59. Line 16. I think the word of should be inserted between determination and whether. The person making the request may petition the Sunshine Commission for a determination of whether the record requested is disclosable.
I think determination whether. I don't think you need the of.
I believe we
How
do.
about to determine?
Well, we
Petition.
could ask, to determine whether.
Yeah.
May
Well-
petition the Sunshine Commission to determine.
Mr. Chair,
Wolf?
I would just say, when you say for determination, it means some action would need to be taken. To determine is a little more, I would think a little more, I don't feel it's the same.
Let's just say for determination of,
Okay.
and move on.
I mean, with
I'm
determination
happy
is a
either way.
definitive, we make a ruling.
All right, for determination of, okay, all agreed.
For a determination of?
Yes.
Of it is.
All right. And that's all I have for 67 point, I
All
think
right.
that's all I have for 67.
Without objection, those are approved and the meeting is adjourned, it looks like.
By default. Yeah.
Okay, well, I do have one other, I do have a couple more things under 67.20I.
Okay.
very briefly on line, this is on page 62. Before before the information, I should say, it should say, I think, in any form in which the information is held. Insert the words "in which" between any form and the information.
On line 5?
Line 5. And on line 8, where it says including disc, tape, printout, etc., I think we should say including but not limited to disc, tape, or monitor. All right, without objection?
Yes.
Without objection.
Okay, Mr. Rustum, you with us? Great. And I think at this point, what I'd like to do, since Mr. Chan since Member Chan has to leave, and we will be without a quorum, what I'd like to do is officially adjourn the meeting. However, if there are members of the audience who would like to stay and give us more comments, I am certainly willing to stay and listen if other members of the task force are willing to stay and listen. So, Member Chan, you're excused. This meeting is officially adjourned. Is there any further public comment? Seeing none, we will close public comment. Thank you all for attending. Have a good evening.